Thanks for being with us today. We're here to discuss a new book today. This is the book by Dana Schmalz, Refugee, Democracy, and the Law of Political Rights at the Margins of the State. And we have with us the author, Dr. Dana Schmalz, as well as Professor Nora Marquardt, who will be responding and reflecting with us on the book. We will handle this as a kind of conversation between us, which I have to say, as a starting point, for me at least, is a really quite moving and special event, because Dana and Nora are two of the people that I personally have learned a lot from in the area of refugee law, and felt that, and also political theory, and felt that we kind of stepped alongside each other, oftentimes thinking on parallel and related lines. And I'll just say a couple of words about each of the speakers. Dana is a research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. She has visited at Columbia University as a research fellow in the Center for Critical Political Thought, as well as taught at the University of Bremen. And she has published this book quite recently, finalizing it in March 2020, as she recounts in the concluding notes of the book, moments that were quite difficult for refugee law and policy around the world, one of the topics that we will surely discuss among us. Nora Marquardt is the chair of international public law and human rights law at the University of Münster in Germany. She has many publications on refugee and migrant issues in leading journals and venues. She is also a leader in the intersection between legal academia and clinical teaching, as well as human rights litigation. And in that capacity, she has both established the Human Rights Clinic at the University of Hamburg, which we have kind of links here at the Minerva Center with. And she's also leading in the Gesellschaft für Freiheitsrecht, which is the NGO that has appeared in many important court cases in Germany. So it's a really great pleasure to have you both with us today. I think the book really raises at its center the problem of refugees as a problem for and of democracy. So the refugees, according to Dana, are not simply a legal issue, not an issue of human rights of individuals, nor necessarily only a response to cases of political persecution. They are a challenge and a question for the very foundations of democratic rule. And as she writes in her outlook part, which concludes the book, refugees mark the fact that we live in one world. It is the legal relevance of the refugee concept that makes it such an important lens in assessing struggles over mobility and political equality today. The capacity to decide who can move, who can settle, where and under what conditions is increasingly becoming the core of political struggles, she quotes Achille Mbembe in writing. And that is generally the topic that I want us to kind of dive into today. What does it mean for refugee rights, refugee policy, and refugee law if we think about refugees as a problem of democracy first and foremost, and for democracy? And to just start us off, I'd like to ask you, Dana, to say a few words about the process of writing, where this book comes from, and a trajectory of your thinking around framing this project.
Yes, thank you so much. Well, let me first say thank you for having me. Thank you, Itamar, for the invitation, and it's great to be here with all of you. Thank you, Nora, also for joining us. I'm really excited about this conversation. And yes, to say where this book comes from. So it has been my PhD thesis that I started writing in 2011. So it goes way back, but it also it's been changing in the way it's been changing in the text, but also in the core motivating issues a little bit over the time. So to say very quickly where it came from, I was studying law. I was interested in international law, human rights, and then I was reading, I was also studying some philosophy, but mostly it were the books by Schmalz and Hinder that really brought me, made me more aware of kind of parallel debates in political thought about boundaries of democracy, about the relations of citizenship and migration. And it was out of a curiosity of how these discourses go together that I really started the PhD project. So if I want to summarize a little bit the turns it has taken, I'd say there's been one important turn that came from a first kind of, I think often when we write against someone. So initially I was writing against a very positivist German legal scholarship that I kind of academically grew up with. So in writing about refugees and democracy, I was interested in what is beyond the legal regulations. How does a democratic theory lens help to problematize certain regulations and ask questions about where are these rules just. So that was a first look, which I haven't left. But then two things happened. One thing was the more I kind of entered in academic discourse, I felt I also looked at a different direction, and that was more to kind of emphasize the complexity that is within the law itself. I also often found that in the political theory discourse, in the political philosophy discourse on those issues on migration and citizenship, there tends to be a bit simplifying picture of the law, as if the law was this one thing, this one power-driven or at least very clear way of regulating migration. And I think the more we look into rules around refugee protection, we often see the inner tensions. We see how the law expresses certain ambitions, but then also limits those ambitions. So I guess one turn in the development of this project was to try to say, let's take the complexity of law seriously and talk about how this also reflects different lines of political thought. And then, of course, the events that took place in those now almost 10 years since I started the project have also influenced how I was writing. From, let's say, a very law critical perspective, the years 2015, 2016 made me more aware how we also need to work with what the law secures. And often, I mean, apart from a PhD project or apart from this publication project, I found myself more and more engaging with the law to say, well, at least let's not violate those rules. And I think this different general attitude that I gained from those years towards refugee law also had its influence on the book, and maybe went together with this attempt to really work with the law rather than against it, if I may simplifyingly say so. But that was the very rough trajectory that this project had.
Excellent. I think that your book really contributes to this literature that talks about law and philosophy, or law and political theory, in a way that is really equally grounded in both fields. So I think that it's hard reading the book to say that this is more a legal work or more a political theory work. It's really at one and the same time kind of emerging from both contexts and not applying the methodology of one context on another context. And that was really remarkable, I think, in my reading of the book. And it goes well with the trajectory that you're talking about. I wonder if you can say a little bit about your choice to choose the category of democracy as the central problem of the book, alongside the issue of refugees. Why talk about democracy, not about other possible categories that can come to mind? For example, the rule of law, human rights, or populism. If there are several different problems that seem to emerge as major in the period that you talk about, and you chose this one. What does it mean to make that choice?
Yes, I think the democratic lens is comes from an interest in where we end up when we talk about legitimacy, and that if we do not have any standards of what makes law just or of what makes law legitimate that are not up for discussion. So if we do away, and I think of course we can claim that there are those standards, that there's a set of values or a certain group of laws that are not up for discussion. But my understanding is that all these norms, even if we use them as reference points of ongoing discussion, they are constantly, there's nothing that is not debatable. And from this understanding that we don't have an external viewpoint, we don't have an external viewpoint to judge, then everything comes down to the question, well, who decides and who participates in those decisions? So I think on the one hand, that's a really general lens that is, before talking about institutions, that is really an understanding of modern law, of law and modernity, if you so want. And then, of course, this idea of democracy enters also a legal realm and a realm of institutions. And what I found interesting, kind of starting to think about the refugee as sort of liminal category, was how there is a universalist core in this concept. And there is also a universalist core in democracy, and yet these two seem to not go together at all. I remember I think in the first year of my PhD, I spoke about the project to an older scholar, and she said, refugees, democracy, that doesn't have anything to do with each other. And I found it is in this idea of democracy as, on the one hand, concrete with institutions and procedures and being eligible to vote, and on the other hand, a universalist core in the sense that it's the procedure for the values of equal freedom and the idea that there is a decision by everybody. So in this tension, I think we also find the refugee. And when I speak about refugees in the book, and here I try to walk a thin line between not essentializing this category in the sense that there are refugees and there are non-refugees, and we just need to find out who fits in which category. But to say, on the one hand, this is a legal concept, which doesn't mean that the way we think about it must be limited to the legal definition, or it must be limited to people who fall under the legal definition. So to say, on the one hand, I'm looking at the law as a source or as also an outcome of normative thinking, but I also think we can look at this category of refugees as a category that extends beyond the law, and that gets also brought back to the law as kind of questioning, is the definition right? Does it still fit the purpose that originally in codifying refugee protection was pursued?
So in that context, you discuss in the book both democracy in the sense of domestic government and the state, basically, and talk about the way that the refugee poses the question, who belongs to the demos that constitutes the political community of basically the state in modern times. But you also talk about issues like voice, participation, in the context of international and transnational legal processes. And what is the relationship between these? Are they, basically interchangeable? Are they normatively equivalent? Is the issue to have voice in some forum, or is the main question for you a question of access to the state in particular, which would assume, I think, prioritizing the state as the kind of normative actor at the basis of international law?
Yeah, that's a good question. I try to look at political participation and democratic membership as something gradual rather than black and white. So there's not one line between inside, outside. So asking who belongs to the demos also is not a yes or no question, or not a who doesn't. but rather I think it's certainly not to suggest that categories of having a voice should replace a stronger membership, like having a right to vote, to be elected. No, but I do think that those different levels of political influence, by having an effective possibility to demonstrate on the streets, to having an effective right to association and forming associations that influence politics, by also those much discussed partial voting rights. I think all this needs to be on the radar when we talk about access to political membership. And I think when we look at those margins, that is why I also believe the case of refugees is interesting for questions of democracy much in a broader sense, is that at those margins, in each of those steps, and in the question of who has political rights to demonstrate, who has the right to vote maybe just in local elections, who has the full set of political rights, I think on each of those thresholds, there are debates that play into questions of, well, I said institutions and universalism, of participating because one is present, or the stabilizing idea of, but we need to distinguish between members and non-members. So I think the negotiations that interest me take place in all these levels. And also, as you mentioned, in international law, although much less institutionalized.
Okay. And related also, I'm kind of curious after reading, what is the scope of political participation in your view? So one view is that really political participation is primarily through state institutions and the right to vote, as you said in your answer. And another view that comes to the fore in part of the sources that you use and parts of your book is that really political participation, also is reflected by movement and the right to move in particular, which you really do emphasize a lot as a political associative right. So movement becomes primarily an issue of association and not necessarily an issue of merely requesting asylum, as one would imagine maybe through a strictly refugee law lens. So I guess the question is, how do these various avenues in your view relate to each other? And does any particular way of participating have a certain priority? And is it, in your view, really the case that this population movements around the world, including of refugees, but not only, are all somehow can be meaningfully categorized as political participation?
Yes, great questions. And I feel that's really an area where I don't have final answers. I try to do something in the book because I need to do something, but many open questions. So I think that I'm looking at where our institutions, but also more generally, what influences a personal situation. So I think democracy is a way to have a say or have influence on what influences your life. So most of the time, the state is the core framework to look at. But in certain situations, like in one chapter, I look at refugee camps. In the last chapter, I look at the international sphere. And I do think about where do also changes for international refugee law come from. That's the last chapter with the participation or some sort of voice in those international proceedings. And for people living in refugee camps, to think about what are the actors that actually influence their daily lives. And I think it's one can at least look at other actors than state actors in that regard. But then you mentioned also movement, and I think it comes from perception that there have been those events that really influence state politics, and where people by collectively moving have really pushed state politics to take notice of their situation. So it comes from a search for the absolute minimum forms of still, even being excluded from political participation on so many levels, still having some sort of influence. So rather than, what I certainly do not want to suggest is that that's all the same. If people can move, they already have a say, so we don't need to worry about other political rights. Certainly not. But on the other hand, by looking more almost like retrospectively, what have been those factors that influenced refugee politics coming from those actors, that the refugees themselves who've been excluded from all like formal debates about the law, I think we can notice how, for instance, the decisions by all those who did not follow the Dublin criteria and stayed where they should have stayed, very importantly influenced European refugee politics in a good way. Well. Okay.
Excellent. I'm delighted to see that we have already questions in the chat from Gadi and from Ruvi, both of whom have, a lot of mileage in these issues. And Ruvi is also one of your, I think, main interlocutors in the book. So it's really nice to have both of you. I'm going to invite other people to also write questions in the chat. I will take them soon, but I first want to turn a little bit to Nora. Nora is, I think, reading this book from a position of a lot of kind of knowledge on all the relevant questions. And in a way, I want to hear you kind of in all of these issues, but I'll start by asking just the general question. What in the book were the issues that resonated for you the most? Where did you find moments in which you identified and kind of agreed? And perhaps, where did you think that you might differ a little bit from some of the points that Dana has made in the book?
Yes, thanks as well for having me. This is a very exciting opportunity to talk to both of you. I really, first of all, enjoyed reading this really excellent book, Dana. One thing that I especially liked rereading it for this conversation is that it's written in very concrete terms in a way. It talks about quite abstract topics, but as you put it, Dana, you don't write about, you try not to essentialize the refugee, but you're also not aestheticizing this sort of figure in international law or in sort of political theory. It's always you always bring it back to very concrete situations. You always say, well, there's sort of global interactions and new political processes that are transnational, but the local conditions remain relevant and people are still in camps and they still maybe don't have access to certain things. So I think that's a great strength of your book that really spoke to me, that you managed to sort of bring these very abstract questions and sort of these very high aspirations of universalism into a very concrete exchange with the conditions on the ground and very different situations that refugees find themselves in. I also thought it very interesting how you disaggregate nationality, citizenship, and non-institutionalized forms of political participation, and sort of thereby, by disentangling these issues that are often thought of as one thing, you sort of draw them apart into this spectrum in which refugees can, depending on the national context, have very different rights and possibilities and modes of participation that are shaped by the law. What I myself, sort of for my own work, have been focusing on is what you say about the role of territory when a lot of the struggles that we're observing right now, at least in the Mediterranean, but I think also off the coast of Australia, are away from the territory. So the question of accessing the territory, being co-present with others, is the very thing that is the subject of the struggle right now. And so this is a site where at the same time states do not exercise jurisdiction, which is what you describe as the reaction of sort of the very fact that political rights react to in this dynamic between the state and the individual. But this is not a lawless situation as such. This is lawlessness by design. It is structured by the states. It is structured by decisions that are taken by states. And yet, sort of, we have these decisions by design create a situation of rightlessness, which of course, Itamar, you've described very, very well in your article on legal black holes in the Mediterranean. So I'm trying to think about this sort of the role of the territory and maybe the efforts to gain access. And I was also very it was very interesting to me how you describe the different ways in which refugees are trying to or have opportunities to influence lawmaking in the international sphere. It seemed to me, though, that this focused quite a bit, and this is structured by the question that you asked, but sort of what also interests me is a complementary thing. You focus quite a lot on sort of official forums, on negotiations between states and including NGOs and including refugee representatives. But lawmaking doesn't just happen, as you well know, in these forums. It happens also, if you will, by the courts through legal interventions, which can be made by anyone from below, if you will. And they can really shape what the law means, as we've seen in the Hirsi Jamal case, which also, of course, comes up in the book. But the meaning of the law is also shaped, I think, especially in the international sphere, by public pressure, by negotiations over meanings in protest, in the press, in political statements, and so on and so forth. And the political practice of refugees, in which I would include their efforts of moving, those political utterances in very practical forms, I think, also shape the meanings of the law and are also a way of sort of trying to inscribe themselves into legal regimes that are maybe excluding them for lack of state presence, and sort of negotiating access, not just to territory, but also to a position of subjectivity in the law. And this is something that I'm not thinking about just me. There's also Fabian Endemann is also present in this conversation. This is a whole group of people at the Institute who are discussing this right now. There he is.
Excellent. Dana, do you want an opportunity to quickly say something about that, or should I move on?
I'll very quickly react. So I think that's a great thought, this last point you just brought up, that I certainly agree that what shapes international refugee law is not just the official forums. And I think what I try to do in this story part is to look how even in the non-institutionalized forms of political participation, the law is involved in framing access to some extent. So it's always this back and forth between saying, not everything that goes into the law comes from the law. It's not just those who've been asked to speak who will speak and then influence what's been decided, but the law is still very present. And I mean, this in a different way, I talk about this regarding rights and protests, but I think the law is present in all of those forms. So I think that's really a great cue to ask more. I think I've really just covered one area in how this is done internationally, and I do agree that courts are important actors, and I've practically not talked about this much. And yeah, so I mean, just to say my lens or my interest would be then to particularly also again ask not just what's happening and where is influence, but also how is the law present in framing those influence, and it could be in framing access to the courts, in framing. And there's another quick point I want to make is, well, also no answer, but just a reaction when you speak about territory, lawlessness by design, and co-presence. I feel that's really a point where I've taken a lot from Itamar's work and this whole notion of encounter, that really I think that's so core to thinking about how politics take place at the very minimum, is to ask, like, where do people meet? Where do those encounters take place? And I think it also pushes us to ask how this relationship of law and politics and the right to have rights that I talk about in the third chapter, where's this very minimum basis of having this relation, of having an influence on what other people will decide on politics. So I think just this is something I keep coming back to and also not covered in the book so much, but this question of how does law hinder or enable co-presence is, I think, very central to asking about first margins of political rights.
Yeah, yeah. Talking from a position of not being present, sadly, in the same room, all of us, and the possibilities that opens, of course. Gadi, would you like to kind of chime in?
Thanks very much, Itamar. So first of all, just to apologize, I've not read the whole book, so whatever I'm noting or asking would be only based on a very small portion of your book. So in a way, it's a chutzpah to relate to a book that you have not completely read, but it might be that some of my queries are already covered in your book, so it would be a good opportunity for you to deploy it. So one comment, it's about the whole concept of law, which in a way is obviously in convergence with the concept of national sovereignty, and I will talk about it very briefly later on. But in theories of law and society, the notion that law is not one cohesive unit is very prevalent since the 1960s. Even earlier. So I'm very interested to know which kind of theory are you using, or what kind of theories are you deploying in order to understand law above the fact that, and I completely agree with you, obviously, that law would not be one cohesive category or unit. My second question is about the whole interplay between empowerment and recognition. Because I think that what is going on with social movements and NGOs dealing with refugees, that they are mainly dealing with recognition, not with empowerment. And it's not the same. Namely, that if you are within the field of human rights and civil rights, there is as much as you can do without going into a better stage of not only recognizing refugees, but also empowering refugees. So how do you look into it? Are you also, in a way, analyzing the whole issue of empowerment above the issue of legal recognition? Two last points. One, it's about ideologies. So on the one hand, I do agree that much of it depends on political participation and legal practices, notwithstanding elite ideology may be quite significant. Because however, how much attention we pay to practices, the question is obviously what would be the legal ideology of controlling elite, of power elite, and I would be delighted to hear more about elite in this game of shaping practices. Last and not least, it was mentioned in Itamar introductions, the whole issue of populism and national sovereignty. So in your picture, in your book, what would be the importance of sovereignty? Obviously, above what we know in international law, and how populism may change the picture.
Dana?
Yes, wow. Those are great questions and also challenging questions. Maybe I'll group the first and the third to talk about the concept of law and those questions of ideology. So I don't think I can give a perfect answer because it's not something I've thought about as carefully as I should have. But I do think I have a concept of law, or employ a concept of law in this book, that is neither looking at law as merely power, nor looking at law as equivalent to a right standard. So what I try to do is really look at legal regulations as the outcome of normative discourses and also influences those discourses. So more in a sort of continuum of between surrounding normative discourse and legal regulations. Now you might say even those legal regulations, or even also Nora spoke about court decisions, all this is only, it's specific in a moment, but there is not one law that could be identified beyond this one moment of decision. So I also do agree that when you speak about non-cohesive, there is the law more as an undecided very often, and yet there are avenues of this undecidedness that run, and they are very powerful in shaping personal situations. So I treat the law, when I talk about legal regulations, for instance, associative rights or refugee law more specifically, I treat the law a bit like making those avenues into lines, even though I'm aware there are more avenues, there's always a level of undecidedness. And especially in the first 2 chapters, when I'm interested in the refugee definition, I'm more broadly dealing with this back and forth between legal regulations that shape our imagination also of what is legitimate, and on the other hand, a normative discourse that will eventually often influence how the law is interpreted. So that's maybe one attempt to answer this question of the concept of law. Then ideologies, I'm not sure I understood it completely, but I'll answer what I understood, and if not, you'll correct me. You say elite and how those ideologies shape also what elites will, how they will structure the law. I do think that's one way also of expressing that the normative discourses are not, how to put it, they might be democratic, but of course there are, you might call it ideologies, or there are certain, there's an aggregation of assumptions after a while that beyond the mere legal regulation will influence how interpretations are gone about. So I think that might be where I agree with ideologies, that there is maybe a layer of interpretations not by court, but in the public, and it could be said in an academic political elite of how refugee law or refugee protection would be understood. That's the most I can say, but again, you might have other thoughts that I'm curious to hear. Then quickly, NGOs, social movements. Yes, talking about empowerment, recognition, one thing I was interested in was to distinguish between actors that are representing refugees nominally, like refugee, pro-refugee organizations, which are doing very good work, but very often do speak for refugees rather than being refugees speaking for themselves. And this question of voice and representation is very complex once one gets into, because no one ever speaks for themselves, or very rarely. Democratic procedures are always representation. So how to really distinguish between forms of representation that we deem democratic and those more attributive representation. And I work with Hannah Arendt's notions of opinion and interest a little bit to try to get a hold on this, but I think what you raise, recognition, empowerment, is very core to that. And populism, sovereignty, again, huge questions. I'll just say, I look at populism in this area of migration often as a way to, well, as a reaction to the complexity and this whole endeavor of trying to describe the complexity rather than reduce it would, in my understanding, be something that we also need as a translation into a political discourse. So I think populism rose from the impression that all those migration issues go to the fundamental security of the, or the fundamental, feeling secure in the sense that there are clear boundaries, and they just are not. So rather than subscribing to a populist discourse, what we would need more, I think, also in practical political discourse, would be in engaging with this complexity. maybe just so much.
Thanks very much.
Nora, would you like to address any of these points?
Now, with a view to time, I think let's hear some more questions. Thank you.
All right. So, Ruvi Ziegler, please.
Hi, hi everyone. Hi Dana. It's I think we, it just shows the times of pandemic. I think I was just telling my husband about our lunch in Berlin. I think in a sunny July 2019 day. So things have changed and haven't. So I read the book and obviously, as you know, this is close to my heart, and I'm gonna refrain from indulging in the bits where there is a more direct discussion related to my own work, and I actually want to ask two other strands of questions. One of them I think relates actually to a point to one of your responses to Gary just now. So I think the first broadly is on this role of representation and participation in camps and the kind of slight oddity of that structure. So I think you mentioned that 31% of refugees live in camps. I'm not even sure if that figure is of UNHCR mandate refugees or if that includes the UNRWA refugee. That figure may actually be a higher one. So that is a first strand of questions, and the second strand of questions is on that link between what you call associative rights, I would call perhaps political communication rights, and formal participation. So on that first strand around the management in camps, I think you do touch in the book, but I would want to hear more about how you see the tension between the fact that whatever representation happens, it is consultative rather than actually directing the operation of the relevant organization, be it UNHCR and UNRWA, and the notion of legitimacy for the existence of those organizations as a quasi or surrogate state, right? Because I think that's a serious question, and the situation of people living in camps, I mean, in addition to limiting freedom of movement in many instances, formally, informally, it almost always limits it, because those are the spaces where people get their services. And so there is a mini state within a state, but it's a mini state without the powers and the full accountability of the state. So I just wonder how you see those two. How do you see those two links? And especially, I suppose, how they then link to the choice of representatives. So one of your response to Gary was on the question of elites and who speaks for refugees, and I obviously agree with you on refugee organizations, but there's also a similar question, I suppose, arising as to who does UNHCR or UNRWA, whoever, consult with on behalf of refugees in the camps, and how does one disaggregate a refugee population into its constituent parts if you've got people from different ethnicities, minorities, backgrounds, and I'm thinking about camps in Greece and the like, and the tension between those groups. So that's one, as you were, a big strand of question. And the second is on, as I say, associative rights and formal participation. So here, first of all, I wonder if you can say a bit more about how you see those two links. Do you see the absence of formal participation as strengthening a claim for the other forms of participation? Do you see any substantive, as it were, normative significance to the fact that, as you point in the book, except for this ordered, provision in the European Convention in Article 16, which has never been used, no other human rights treaty allows formally for a limit on associative rights for non-citizens, and within that refugees, whereas almost all of them explicitly or implicitly limit formal participation to citizens. So how do you see those two related? And finally, what role do you see precarity playing here? I think you do mention in the book, the fact that whereas people may have a right to say protest, if they are asylum seekers in a process where their applications are pending, they may be very reticent to participate. how do you see the precarity of resident status playing a role in associative rights? So I know there's a lot there, so don't feel obliged to answer everything, but I really enjoyed the book.
Thanks, Ruvi. Wow. Dana?
Yes, I'll take much of this really also as inspiration for further thinking, and it's so special to see you here. And I do remember our last lunch too. It feels like yesterday. But so to start with the first threat you raised with representation and refugee camps particularly. So, I mean, it's a difficult area to talk about also for me because I only rely on scholarship of others to even talk about those issues. So I rely on ethnographic scholarship, I rely on already reflections about those political situations, but I feel that leaves me more than in the areas where I am more directly addressing political theory or legal theory questions. I feel there's an immediacy to that. So in that case, the first thing I found interesting was to see that there are all those formal endeavors by UNHCR to give some sort of representation to people. So I think it is interesting at first as a sort of recognition that there should be something like political participation. And then at the same time, everything that takes place, I view as you've described it. It's only consultative, it's very often problematic, it very often serves to fortify governance rather than control it. And I think what I take from it is that, well, it doesn't do away with the fact that that's the only thing that people have in those situations. And I think we should take seriously the fact that the main actors shaping the living situations are not the state institutions, but those humanitarian organizations. And that leaves us with a picture of a pretty far-reaching absence of any form of political rights. And what this comes down for me is, on the one hand, to really say the question of political rights directly leads us to those overarching framing arrangements that put people in those humanitarian government situations. So in a way, it refocuses the view on questions of responsibility sharing, of questions of humanitarian governance, as that really makes clear how problematic that is and how this being kept in a perpetual refugee status situation rather than on a road to citizenship is kind of reflected in this far-reaching absence of even the very basic political participation rights that might be there in the state. So I view it mostly as an absence. Then still, of course, one can talk about how certain aspects of this representation might go into a direction of influence, voice, but my main impression would be that it tells us more how the framing arrangements must be changed. Then there could be so much more to discuss there, but I'll leave it at that. And then the political communication rights, I'll use the term for now. I try to not, well, you ask how to, if there's anything normative to draw from the fact, if I got you right, draw from the fact that there is an absence of formal rights of participation, kind of saying because we don't have, for a group of people, we don't have formal participation right, at least they should have this. I think we can say that, but then for most trying to look at how, well, what do we find, what is there, and to, well, see the evolution of how constitutions have framed those political rights, freedom of association, freedom of assembly, as something that used to be more, at least normally, limited to citizens, and then has been broadened. Now, of course, in practice, it applies through European Convention of Human Rights, etc., applies to everybody. But I think there's been a development of looking at those rights. And I would fully agree with what you say, that the main focus should be how all those other factors, like precarity of residency status, impact those rights, and how, particularly for persons for whom this could be the only avenue to participate politically, we should take this very seriously. In Germany, this also applies to those residency restrictions that restrict freedom of movement really to a small area. But I feel you put it so well. I can't add really much, but I'll just say I agree. So thank you so much.
Thanks very much. We'll continue at some point.
Nora, would you like to offer anything?
Yeah, thank you. Just maybe I would like to add one little aspect that I think is sort of in the book, but maybe something that could be teased out a little bit more, because as soon as you start including refugees in any processes as a group or as persons, as representatives of the category of refugees or the group of refugees, which is not really a group, you encounter a lot of problems that I think have already been discussed in the context of multiculturalism. You institute a form of identity politics, if you will, where people speak for a group that doesn't really exist, and where their own positioning is also particular often in a lot of ways. In multiculturalism, this goes under the slogan of minorities within minorities, especially the role of women, for example, within cultural minorities have their own rights within states. I mean, that's the setting that this is discussed in. But I think in refugee activism, we see a lot of that as well. So we have refugee women, for example, forming their own associations and negotiating the conditions in the camps or in the squats that they form, and claiming their own voices and so on. And when you sort of subsume them all under the category of the refugee that has certain interests that are specific to refugees, I think you do not sufficiently take into account any minority groups within that category of persons, be it women, be it LGBT individuals, any other vulnerable individuals within a certain group, or also political tensions, obviously, within refugee, sort of a refugee category that includes people from very different backgrounds with very different worldviews of what politics should look like, how would they want to organize themselves, who should have a voice, and so on. So I think that is important to bear in mind. And then just a brief final point, the political rights that you talk about, I think, are also very important within the state that refugees arrive in, but at sea, you encounter the problem that sort of without a state to exercise jurisdiction who has obligations to respect these rights, you have moral rights, but you're basically in the situation of rightlessness that Hannah Arendt describes for the stateless. You're just a human being, and you have rights that come from being a human being, but they're not actually legal rights because you can't enforce them. There's no other that you can make them count in relation to. So this is a situation where obviously refugees use their voices without relying on political rights. This is the rightlessness in the age of rights situation in a way. This is also something that Isama, of course, you've written about in the German Law Journal article, I think. But the political rights only go so far, even in that sense.
Yeah, Nora was just making reference to also a book by Ayten Gündüz, Rightlessness in the Age of Rights, which I think is also one of the kind of, if you want to write a syllabus of fundamental texts that are kind of in this crossover between refugee law and political theory, it's really an important contribution to that debate. And I want to follow up on your comments, Nora, and ask you both a question. I see Rajesh Kumar has asked questions in the chat, and I will give you the opportunity to speak if you want. I also know that Eli Salzberger, our director, is on the list, and now Professor Stefan Euter from Hamburg. So I think that we will have an opportunity to hear everyone, but I do want to take my prerogative to ask what I think is a really important question in this conversation. And it starts from, I'd like to start by addressing Dana, but also hear Nora on this. And the question is, what does it mean to choose in such a book and in such an argument about democracy and movement rights, the category of refugees rather than the category of migrants? So of course, this is a foundational debate within the community that is interested in mobility law, if you will. And from the point of view that you articulate, I think it's obviously correct that when we're talking about refugees, we have much more to work with in terms of established rights in positive international law. And unauthorized migrants, I'm not talking about authorized migrants, but unauthorized migrants moving for economic reasons are generally, unless they may suffer from ill treatment, are generally not equipped with this legal arsenal. But from the perspective of making claims and distributing resources in particular, it seems that economic migrants are also really an important part of this question. And when we think about democracy, we're thinking essentially of a procedure to distribute resources within a certain political community. And where do migrants who choose to move in order to distribute, in a way, the available global resources, where do they fit, if at all, into your picture? And could it even be the case that by not writing about migrants, you are somehow contributing in a way to kind of overlooking that question, which obviously has enormous effects also on citizens of democracies that oftentimes frame their objections to unauthorized entry in economic terms that have to do with the distribution of resources. So if you may, please address that basic distinction and where your position stands on this debate, whether the basic category of this democratic call to open the limitations of the demos includes only recognized refugees or migrants writ large, or perhaps some position in between. I'm also curious what Nora has to say about this. Nora has written a lot about social economic rights alongside her interest in refugees and migration.
Yes, great question. I'll say to whom the arguments apply, why I chose the refugee, and then why I still think you have a good point in problematizing this. So who does it apply to? I think when I speak about refugees, I do not mean only those who fall under the refugee definition of the 1951 Convention and the Protocol. I think it is broader, and I try to make this clear in discussing a little bit that there are alternative definition, that this is more a whole range of still contested legal definitions and a category that is composed by them. So it's broader than the definition. It also, I think, applies much of what I say to migrants, even if I speak about refugees. So much of this margins of political rights or the access to political rights is something that even if I choose the refugee lens in a way, does apply beyond refugees in that sense. So why do I choose the refugee category? It comes from a hesitancy to engage in a sort of a comparison between an ideal state of the world, how I think it should be, and then the non-ideal situation, and kind of saying it should be different and this should be changed. I think I've been hesitancy because who am I to describe the ideal world? And it comes from really a theoretical conviction I have that we only argue from our situation, and all our normative assumptions are also situated. And so I find it a very honest way of engaging with those questions, kind of from an immanent critique. And that's what I try to do. And I certainly fail many ways, many steps on the way. But this immanent critique, in a sense, is to look at how the refugee concept, as we find it in law today, stands on several strands of political thought and what I call a normative idea of the refugee. So what I think we really can see is that in the development of the modern state as a territorial state, where rights and obligations are kind of delimited along territorial lines, there emerges an idea of an exception towards the stranger at the border. And I think this is really foundational, and it flows into it, is part of what then becomes codified as the refugee concept. And it's this foundational idea of an exceptional duty towards the stranger that makes me so interested in the refugee concept, and kind of the entanglement that comes with it, that once we recognize that this idea is foundational, then all the subsequent questions of, well, who gets to decide where to set the particular criteria of this refugee status, they already become a big question mark in terms of democratic theory, because once you recognize this is more, or this is as fundamental as the territorial delimitation, you can't just say, well, we'll decide from the inside. So that's a kind of practical reason, or a theoretical reason. And more pragmatic is also that I think we, in today's discourse as it stands, I view the refugee concept as a sort of block in the door, that this is the one way of arguing for entry rights, and we would be left with very little if we were to give it up, because then there might be, we are going back to God's questions about populism and sovereignty, there might be just an argument of, well, we're not interested in those moral ideas about entry, we will just go with the law, and the law is the state. And so that's why I think the refugee concept also strategically is valuable. Now, to close with the last point, I said, I still think you're very right to raise the question if this kind of reinforces a distinction between moral claims based on need and based on a situation of hardship, what the refugee concept somehow about, as opposed to questions of economic distribution. And I do see that even if we keep challenging the specific criteria of refugee status and say, well, this has to be developed, we have to question, we can, with the Cartagena Declaration, for instance, bring in human rights violations into the refugee status, still there, I think there remains a core that is based on moments of hardship rather than broader distributive questions. And I don't have an answer. I think that's an important point to further think about. Yeah.
Nora.
Yeah, that's a really great question. I'm still thinking about what I could possibly add to what Donna has said. I think I share to a certain extent your pragmatic approach, Donna. I used to think that we should give up the refugee category because it's just so hard to really distinguish it from other forms of forced migration, and because usually migration motives are quite mixed, and the situation of precarity is usually comparable, and so on and so forth. I've kind of retreated from that position to a certain extent in acknowledging that the sovereignty paradigm is extremely strong in migration law. So states will assert the right to exclude non-nationals from their territory at their discretion. And refugee law only basically works because it's an exception. States accept it because it's not the rule, because it's at least in theory limited to a certain category and subcategory of migrants. And so I think it's probably more promising to negotiate the meaning of refugeehood and to see how this concept, which in the past has already proven to be quite malleable and flexible, how it can respond to new problems that we're raising. And for example, Michelle Foster, I think, has written a really excellent book on refuge from deprivation and socioeconomic rights and refugee status, and has really explored how the concept of socioeconomic rights can be used in relation to the concept of persecution, and how socioeconomic deprivation is usually not, does not affect everybody because societies are not structured in a way that it affects people equally. There is usually inequality within societies, and that usually maps onto the categories of refugee status, race, religion, nationality, and so on, gender, of course. So I think there's ways there, and I'm not sure that migration law and sort of the status that it seeks to secure for those who are migrating is the the tool with which we can really talk about global inequalities. And I think we have legal avenues to challenge this. And of course, climate migration, I think, is one way that is very important. And maybe where there's sort of a nexus between the issues of sort of global inequalities, by holding states who are contributing massively to climate change accountable in these very, very isolated cases of one person whose island state will be disappearing soon. And, do they have a right to be protected by another state? Does anybody have to take responsibility for this? But I think sort of this is complemented by cases brought against states more generally for damages, for example, for environmental changes in countries. And I think that's a very interesting way of, again, framing claims that are not yet on the wall, if you will. They're not yet foreseen in the legal system that we have. And that, again, is a way of claiming rights that one does not yet have, and a sort of a performative stance of declaring rights that don't yet exist, and thereby declaring them into existence and trying to negotiate them into legal positivity, at least in some way or other.
Thanks. Excellent. Rajesh Kumar, would you like to ask your question with voice or with voice and camera?
Yeah, hello. Namaskar to everyone. Am I audible?
Yes, absolutely.
Yeah. My question was, like in India, you can call it a refugee or migration situation because in the initial stage, it begins with the economic conditions. When the people from the poor country or poor conditions, they migrate to the countries which provide better facility to their life. But on the refugee context, we can say that they are running for their life, not just for the betterment of their life. Their life is at stake. Then they are moving to other countries. For example, it happened in Syria and people went to Europe. So when migration happened, the country where these migrants are reaching, they're facing very huge problem of political manipulation. For example, in India, the state of Assam, which is in northeast part of India, there the Muslim population from the Bangladesh migrated. Now the population is at very high pace increasing. So in such a situation, the local people or the resident of that area, they are facing a democratic imbalance kind of situation. And the political scenario is also changing because of that, because the political leaders also supporting due to their vote bank politics. So I just want to know what should be the solution to these questions when we allow migrations, because when we look from the human rights perspective, we should allow them, no problem that. But when we look at the situation and problems arise after their migration, then who is going to be responsible for that? Because human rights agencies, they talk a lot about that thing, but they don't want to fund the poor country or for example, India is not that much developed country. Its own citizens are not that much having all the facilities. So India is not able to feed its own citizens. How can it provide the other migrants? So,
thank you, Rajesh. May I ask you, where are you speaking from today?
I'm in New Delhi.
New Delhi, excellent.
Yeah,
it's great to have you. Dana, would you like to respond?
Yes, I'm happy to say a few words, although I feel these are it's a big issue, this question of minimum economic rights, which might not even then be so specific to refugees. But I think one point, this is what is really interesting about what you asked. It goes together with what Nora said earlier about representation, sort of identity politics, this whole question of what's there beyond the perspective of human rights that kind of looks at humans to some extent in the abstract as saying there are minimum rights and they apply no matter what. But of course, there's context. And I think we shouldn't be blind to context. And it might be in the case of representation to say, well, there's always more also to an identity than just a refugee situation. And there are groups and there are group identities and there are all those specifics that then in political voice will also play a role. And what you raised was questions of demographics. From a different side has the same question in mind. I think that we cannot be blind to context, that on the one hand we have a perspective of human rights protection or of refugee law, which does not look at a question of who else is there, but really at the individual and the claim to protection. And at the same time, yes, for state politics, those contexts will matter. Now, I think that the refugee law, as we have it in international law, human rights law, pushes us to kind of prioritize, at least at this minimum level of saving lives, of saving basic freedom rights, to prioritize a perspective of rights over considerations about demographics. And that might be politically challenging. And I think the answer cannot come from international law and kind of withdrawing and saying, well, it might get complicated with demographics, so we'll just like scale down those rights a little. I think that's a decision that international law has taken, and that stands again, I think, on a whole thread of universalist thought to prioritize the survival of every individual over demographic considerations. But I do see that this is unsettling in a way, well, all depends from context and how unsettling this is.
Quickly, just in order to see if you have any other comments on this last intervention by Rajesh. Okay, so let me give the floor to Elie Salzberger.
Thanks, Itamar, and thank you all for this fascinating discussion. Minerva minds think alike, because I was about to ask Itamar's question about the distinction between refugees and immigrants, but I'll make it a bit more general and resort to the main theme of your book, democratic theory. And I can understand how democratic theory should affect immigrants or refugees once you let them in. But I want to press you on the core philosophical issue, or political philosophy, of what is the stance of a democratic philosophy with regard to allowing people in, either refugees or immigrants. I think, you know, some of the things that we heard about Australia keeping refugees offshore, building a wall in America, is behalf of democracy or democratic values. And even if you take a more deeper, thicker democratic theory, in a sense, even paradoxically, you know, a thicker democratic theory gives a very, very big weight to the demos, to the social contract, to the people that constructed the society, and therefore some legitimation to prevent others from coming in, unless, you know, you are bound by international law, but then it's law and not democratic theory. So my essence, basic question is, how does democratic theory restrict our or direct our policy towards admitting people into society?
Yes, thanks so much. That's really to the point. And I'd say, first of all, certainly no democratic theory will give an answer in terms of concrete politics, kind of dictate what political decisions should be taken in admitting people. And I think of it on kind of a spectrum of how this balance between universalism, openness, inclusion, that's part of democracy, and institutions and stabilizing and what you call like a sense of democracy as demos, how this balance is taken. And I think there are different ways of describing this relation. One can not do away with either side completely. I think a democracy that's only institutions enclosed and says we once decided who has the right to vote and we will never touch this question again, I don't think we would consider it ever democratic. But on the other hand, we also cannot have a democracy that's only inclusion and no like stabilizing institution at all. So I think I think about the different theories and thinking about theorists like Michael Walzer, that is somehow on the spectrum of how to balance it. And then on the spectrum, I would see myself, first of all, my first claim is to really put the spotlight on the question of entry being a democratic question. And that's where precisely with the refugee concept, I think we end up to say, once we accept that obligations are not starting after the social contract, but a kind of equiprimordial, they are already in the same era of thinking about rights that they emerge. I think at the moment we have to accept that even with a thicker democratic understanding where we place a lot of weight on institutions and existing demos, we will still have to think about those questions of access as somehow bilateral. There's always an outside that also wants to have a say, not just a right to be admitted, but also a say in what the criteria are to be admitted. So that's one practical claim I'm making, that there is this outside and that it is a question of democracy. But I think after that, it becomes a question of politics and no longer of theory, really. So I think there's a huge spectrum of how those claims could be administrated, how this giving some voice then could actually also lead to a claim to admittance. So I don't feel it's my task as a theorist to then really give more concrete answers to what democratic theory says about entry, but this an attempt to describe a little bit how far I see my reach in thinking about this.
Professor Stefan Euter, please.
Yeah, nice to see you all. My question is a bit following up on Ellie's question just at the moment, and it's on theoretical underpinnings. We have an interesting parallel discourse to our lawyers' discourse on refugee law in political philosophy under the heading of international justice, and there's an interesting sub-discourse on migration and international justice, where we have the typical kind of extreme poles, extreme cosmopolitans which reject any legitimacy of territoriality and borders, and radical communitarians which deny that it makes sense at all of talking of an international dimension of justice, that justice is something which works only in pre-existent constituted communities. And I would say the interesting debates take place in the middle ground at the intersection of the two poles, and that's a bit which is following up on Ellie's question. I think the authors like David Miller, or in Germany Julia Nieder-Rümelin, they are grappling with that question. Even if you start from a cosmopolitan underpinning, isn't there an intrinsic value of kind of historically constituted communities and a legitimate concern of these communities with preserving a core of cultural identity, societal cohesion, which forces you to compromise as a cosmopolitan, to compromise with, in a way, Gadi's sovereignty concern, which doesn't say, compromising doesn't say you accept the sovereignty concern as a concession to realpolitik, but there's a legitimacy of this claim, which you have to work into the discussion of refugee law. And I would be interested how you, Dana, see that kind of that struggle with the intrinsic value of pre-constituted communities.
Yeah, so I feel that's so, at the same time, such a deep theoretical question and also very concrete, because of course all those issues when we were discussing Obergrenzen, I don't even know how to say, like limitations on how many people to admit and all this, then those arguments had a very direct political influence. I think, first of all, often the translation from the theoretical into the concrete political is difficult, because what is this core of cultural identity? What is this historically grown? I think very often the sovereigntist defenses work with simplifications, but putting those aside for a moment, I do see that this is a real argument. It goes also back to what writers Kuma raised, that there is context, there are specific historical settings, and the support for international refugee would be sinking if we were to say, well, all these needs to be ignored. I still think that we should see how, when accepting those minimum obligations that states have under human rights law and international refugee law, there remains a huge field of political design or of political decisions in how to govern migration. It's not that international refugee law dictates migration to a great extent, and then all these questions of how to administrate entry, how to administrate also access to citizenship were gone. And I think it's interesting how, on the one hand, before, when talking about the refugee migrant dichotomy, we kind of have this worry that all claims to entry go away completely, that the law is not strong enough to enforce even this minimum access that we see as necessary. And on the other hand, there's this fear that if we accept refugee law, then we've lost all control over our composition of the population. And I feel it's somewhere in between, and maybe the answer is really to accept that there is this radical openness in some way when we accept the premises of refugee protection, when we accept the premise of refugee law, that yes, theoretically, this really could mean a change in demographics. This really could mean even a change in those historically grown communities. But I also think, looking at the practical politics, it might be neither of the extremes so much, that we are very far away from losing our control in this. And I think there's still also, after a first admission, a first protection, there's so many more steps of people becoming part of the citizenry that, I guess my only answer is that I often find those worries overemphasized politically, but I see the theoretical challenge that they represent.
Just to check with Nora once again.
Just briefly, I think I mainly agree with Dana. I think Stefan Uta put the question very well. Is this not just a pragmatic thing, but is there a certain legitimacy? And I think if we take human autonomy and the right to self-organization seriously, then we must accept that humans will make different choices in how they want to live their lives and how they want to organize. I think the main problem with these more communitarian-leaning approaches is that they seek to essentialize those choices and ascribe them to ethnicity and cultural sort of a cultural essence of certain people, and that are then also ascribed to those coming in from outside who are seeking to be members of the exact communities that have already formed and who want to subscribe to the values and benefit from them. So I think that generally the organizing humanity into different communities with their own rules, I think is something that I cannot really imagine giving up, because that would mean flattening out all the sort of differences that humans will find important for their own lives. At the same time, the way that this is used to frame certain debates over who gains access to communities, I think is highly problematic and often framed in sort of subtly racist terms and I think that is very, very important to disentangle. So I think, there is a certain legitimacy to it, and it's also used in very problematic ways otherwise.
Okay, we're quickly running out of our time for this session for today, but we still have one more person who requested to ask a question, Jose Ignacio Hernandez. Are you interested in speaking?
Oh, yes. Hello, everybody. It's a pleasure to be here. My name is Jose Ignacio Hernandez. I'm a Venezuelan law professor, currently into exile in Boston, and working at the Harvard Kennedy School. Congratulations for the book and the event. And I just have a very particular question regarding these temporary protection measures like TPS that has recently granted in favor of Venezuelan migrants by the government of Colombia and the United States. And I would like to have your opinion about whether those kind of temporary protection measures could be proper mechanisms to assure refugees political right. Thank you so much.
Excellent.
Yes, very quickly. So I think the question of political rights is not per se affected by, I'd say, by this how the residency pyramid or the duration of protection is framed initially. I think this question of political rights exists in the moment where a person is present, affected by the laws. But of course, then the temporary protection mechanisms kind of give expression to a certain idea of what's happening with refugee accommodation, or what's happening with hosting refugee. Is it kind of a form of immigration that might end up in access to citizenry, or is it more temporary protection that is supposed to end and then the person returns? So I think in this thinking about political rights, this direction, whether it's a temporary protection situation or more an avenue to citizenship, is of course very important. And I think, and the temporary protection mechanism that you talk about very much fall on the side of saying, well, this is just protection for a while, this is not immigration. So I think this affects the thinking about political right in that context, but it doesn't do away with what we spoke about, for instance, right to assembly, right to association, all those forms of like legally framing non-institutionalized political voice are still relevant also in those situations.
Nora, on TPS, if you want. Okay, so with that, I think that we can conclude for today. I want to just offer a few remarks that are essentially intended to say that this is a really wonderful book and very warmly recommended for those who are working in this area, and for people interested in political theory more generally. I think it's a really important contribution that I will end up coming back to often in my work. I'm also very, very happy that we were able to have this kind of transnational conversation. It felt almost like we are creating a kind of common space. I think Germany and Haifa were kind of, in this co-present for a moment. And and with two of my dearest colleagues, this was especially kind of happy and encouraging for me in these times. I'm also really happy that we had contributions from New Delhi to Boston, to Venezuela via Boston. And with that, I'd like to just thank everyone for being here and say goodbye, and hope to see you in other Minerva events.